Yeah, all right. Thank you very much. It's fantastic to be presenting this work. Wentao and I had the opportunity to present it a few times this month already, and it's great to see that there's so much interest into this area. As a heads up to everybody, this was supposed to be an applied modeling talk, and it will be an applied modeling talk. We had some scheduling change, so if you expect inference, there will be no inference in this talk. Credit goes to Wentao. Due to visa issues, he can't be here, and you're stuck with me. And the focus of this work is on the dedicated docket, which is a Biden administration policy for the asylum system. And I'm going to start by giving you a little bit of background on the policy, on asylum, then a bit of background on the policy, and then I will tell you how we are modeling this policy and what our takeaways have been. Now, the first bit of background about the US asylum system is that there's consensus that the asylum system is broken. This applies regardless of whether you ask people on the left, people on the right. There's a consensus that the asylum system is not working. But what does asylum actually mean? Broadly speaking, asylum is a sort of protection that the United States government offers to people who are unable or unwilling to return to their home countries because of a credible fear. Credible is a word that I'm not going to define because that gets me into political issues I would like to avoid. Because of a credible fear of serious harm. And usually, if you read the New York Times, you will have noticed that this may have changed this year, but usually we're talking about people who are already in the United States or who are seeking admission at a port of entry. There are two different types of asylum. One is affirmative asylum, which people can apply for without there being any removal proceedings against them. And the second is defensive asylum, which is a sort of defense against active deportation proceedings. So if somebody already has proceedings running against them to get them out of the United States, they can apply for defensive asylum, and a hearing in an immigration court then assesses whether or not they are eligible for asylum, meaning whether or not they fulfill this condition. And that will be the focus of this talk. Now, when I said before that there's consensus that the asylum system is broken, a large part of the reason for that is that the backlog of the asylum system has gone up by a lot over the last decade. So it used to be at about 100,000 for quite some time. It was stable at that level. And at this point, the backlog has grown to more than 1 million cases, meaning more than 1 million people have applied for defensive asylum and are waiting to have their cases heard. If you are an operations researcher, you're very familiar with Little's Law. And Little's Law tells us that as the backlog grows, the wait time should also grow. So the amount that people have been waiting in the backlog went from something like 2 years to, at this point, more than 3 years. This is not the wait time until the hearing. This is the wait time that people have waited already. And they may wait another few years before they get a hearing. In fact, there have been some headlines, for example, here in AP News, immigrants waiting 10 years in US just to get a court date. So this is the background of why people view the system as broken. And this also explains then why, for example, the Biden policy, but also other US administrations have been trying to address this issue. Now, one way to address this issue has been the dedicated docket policy, which the US announced 3.5 years ago. Attorney General Merrick Garland made clear that the goal of this idea of a dedicated docket is to adjudicate cases promptly and fairly. But what does dedicated docket mean? Docket really means a queue at a court. So prior to 3 years ago, there was just one docket, which you should think of as everybody shows up, they wait for a court case, and they wait for multiple years. But the dedicated docket would effectively create a fast track where people would wait less than 300 days. So you go from a system where everybody waits in the same line to there being 2 separate lines, and people get assigned to one of the 2 lines, and depending on which line they're in, they either get a decision very fast or they need to wait much longer. This is not entirely new. Similar policies have existed before, both in the US and abroad. And it's been criticized both now and both 3 years ago and in the past for violating fairness. So here's a quote from the Bar Association of San Francisco: "The dedicated docket undermines fairness, prioritizing expediency with no other perceptible benefit." That is really what we're trying to understand. Does it really undermine fairness, and does it do so with no other discernible benefit? So the two questions we're trying to ask in our study is we're trying to design a model of what this dedicated docket entails operationally, and whether it really doesn't have any benefits, and whether it really undermines fairness, at least within our model. Now, there are a few things that our model tries to capture. One is the average weight of cases in the court backlog, because very clearly that is an issue that people have been concerned about. The second is accuracy, the fraction of correctly adjudicated cases. This is a big part of the reason why we use a stylized model to study this setting. We cannot really assess for any case in the real world whether or not they merit asylum, but we can create a model in which people either do or don't merit asylum, and then we can say, well, out of the cases for which we know the ground truth because they don't exist in the real world, they just exist in our model, how many had their cases correctly decided? And then the last part is fairness. And what we mean by fairness goes back to the Bar Association of San Francisco, which is the docket assignment, which happens prior to a court making any decision. The docket assignment should not determine the chances of a case either getting asylum or not. So that is the third piece we try to capture in our model. And what we will find is, on the one hand, that the dedicated docket can actually Pareto improve these two aspects. But what we will also find is that in order to do so, it must violate fairness. This is just a preview of the results. I'm going to formalize all of these in a little bit more. But I first want to give you a bit more background on the fairness issue. In particular, there are observational studies of the dedicated docket and the regular docket, and they look at two aspects. One is, how long do people wait? And in fiscal year 2022, the average wait time on the dedicated was 276 days. Remember, the policy goal was 300 days, so this is working as intended. But the probability of a case on the dedicated docket to be granted asylum is only a little bit more than half of the probability of a case on the regular docket. So that's where the concern about fairness comes from. What explains these poor outcomes? There are two reports, one out of Harvard Law School, one out of UCLA Law School, that are trying to dig into that. And what they find, nope, still not the one I'm looking for. That's the one I'm looking for. What they find is that the main issue, one of the main issues at least, that drives whether or not a case has any chance of being successful is whether they have access to counsel. So whether or not they have access to an attorney that helps them with their asylum case. Among the people who were granted in the Boston Immigration Court asylum, 100% had access to an attorney. Not a single person without access to an attorney was granted asylum, which tells us that representation really is crucial in this context. And if you then want to know, well, why are dedicated docket cases so much less likely to be granted asylum? Well, they are much less likely to be represented. In LA, for example, 70% of cases not on the dedicated docket have access to a lawyer, but only 33% of the cases on the dedicated docket. Why is that? The Harvard Law School report writes that the expedited and unpredictable nature of the dedicated docket makes it difficult to properly and effectively prepare asylum cases within the expedited time frame. So that is the background that we're using as we're setting up our applied model. To summarize it, we find that the dedicated docket indeed operates much faster. We find that cases have a much smaller chance of a positive outcome. And we find that lawyers tend to avoid dedicated docket cases because of the short timeline, which is a problem because representation is effectively, empirically speaking, necessary for a case to be successful. Okay. Now, what we're trying to answer is, what is the underlying mechanism that drives the unfairness? And on the other hand, could a different implementation of the dedicated docket maybe avoid the unfairness? Maybe the dedicated docket, the problem is that the policy goal is 300 days. Maybe if it was 325 days, the outcome would be better. So we're trying to understand what is really at the heart of the unfairness here. And to answer that, we're going to analyze a stylized queuing model with the following features. We're going to have heterogeneous asylum seekers, policymakers that care about the three objectives we mentioned above: accuracy, delay, and fairness. We're going to capture a court that tries to minimize the delay, and we're going to try to capture lawyers' choices. Let me try to formalize how we do this. We have asylum seekers that arrive with person arrival rates, lambda k, and they are distinguished by a type k that captures the probability that they merit asylum. We can also have just one type. If cases are homogeneous, to some extent, we are indifferent between that. Now, they arrive to either the regular or the dedicated docket. This decision will be made by the policymaker. And the lawyers who are capacitated, they cannot take on every case. They are choosing which of these to represent. And then one of the following things happens. If no lawyer takes on the case, then the case is denied asylum, which matches what we observe in reality. If a lawyer takes on the case but does not finish before the court date the preparation of the case, we assume that they are also denied asylum. In the paper, we relaxed that somehow for the purpose of this talk. Let's stick with this assumption. And if a lawyer takes on the case and finishes all the preparation that's necessary, gathers all the documentation that's necessary before the court date, then we assume that the system is accurate in the sense that if the case does not merit asylum, remember, there's a probability over here of that being the case or not, then they are denied asylum, and otherwise they are granted asylum. This is, of course, a massive simplification of a very complicated system, but it allows us to focus on the effect of what happens when you have two dockets versus having just one docket. Now, there are also a lot of different choices going on in here. But before we get to these choices, let me just highlight, in these two cases here, if a case merits asylum, then we have an inaccurate decision because the case nonetheless is denied asylum. Now, what decisions do we have? We have a policymaker that needs to decide for every case that arrives which docket they are assigned to, and that needs to decide on the delay target for the dedicated docket. Is it 300 days? Is it more? Is it less? What should it be? And that policymaker cares about all three of the objectives we mentioned before. We have the court that really gets criticized for the long backlog, so they want to minimize the combined backlog on the two dockets, subject to the constraint that they need to meet the delay target that the policymaker set for the dedicated docket. And we have the lawyers that need to decide which cases to prioritize to take on. And the lawyer cares about their success rate. And because we assume that successes are, that the system is accurate for all cases that don't merit asylum, maximizing successes is the same as maximizing accuracy within the model. Now, this is a somewhat complicated multi-agent system, but we can analyze it sort of one step at a time. As we do, we will identify the following. The first part that should be quite intuitive is that there's a trade-off between delay and accuracy. The reason is that lawyers need to finish preparation of a case. If you imagine a world where lawyers only have a week for every case, they won't ever finish the preparation of any case, so every case is denied asylum, and only the cases that don't merit asylum are decided accurately. Whereas if you allow for more delay, lawyers have more time on average, and they manage to prepare more cases fully. So there's a trade-off here. The second result that we identify, within our model at least, is that for a sufficiently large average delay, the policymaker can set everything up in such a way that the accuracy is strictly higher on a 2-docket system than it would be on a single docket system with the same delay. So pictorially, what that means is that we still have a trade-off between a 2-docket system and a 1-docket system, but the dedicated docket actually moves the trade-off up. And I want to explain what that means. What that means is that strictly more people who otherwise falsely would be denied asylum are now granted asylum thanks to the dedicated docket. So if what you care about is the maximum number of asylum seekers to receive asylum, if that is the objective, then the dedicated docket could actually help with that. This plot here assumes that we have heterogeneous cases, but the theoretical result also holds true when the cases are homogeneous. The magnitude is just a lot smaller. Now, yeah, question.
In the previous graph, is the dedicated docket system, like the graph on the left, is that dedicated docket system plus regular docket system, or just?
Yes, this is across all cases. Across all cases, what is the accuracy? And the average delay is also across all cases, what is the average delay? Now, one piece that's crucial to that claim is that in order to get this improvement, the policymaker needs to be very careful about how they set the delay, which cases they route to which docket. So what we did here is we effectively plotted over a very large grid all kinds of possible decisions by the policymaker. And we find that, yes, there are a lot that Pareto improved the outcome, but there are also a lot that Pareto worsened the outcome. So it's not the case that a dedicated docket is guaranteed to improve outcomes. It's just, with the right decisions, it can. Okay, so going back to the Bar Association of San Francisco, they claim that there's no discernible benefit and that it undermines fairness. If I trust my model, I would at least say that there can be a discernible benefit. But how about the other part? Does it undermine fairness? What we can show is that for reasonable definitions of fairness, I will get to them in a second, a 2-docket system cannot Pareto improve over a single docket system unless it violates fairness between dockets, meaning unless one of the 2 dockets is systematically discriminated against, people on that docket have systematically a worse experience. And what do I mean by fairness in between dockets? We have 2 definitions, and you cannot fulfill either one while improving over a single docket system. One is, on average, lawyers should spend the same amount of time for cases on each docket, or at least it should be compatible with how they make their choices for them to spend the same amount of time per case on each docket. And the other one is what we call fairness in outcome, which you should view as, in our model, every non-meritorious case is denied asylum. So we would want it to be the case that if you're meritorious, regardless of which docket you're assigned to, your chances of getting asylum are the same. Nobody's been pointing time to me, so I don't know how I'm doing, but I'm just going to assume I'm fine. One caveat I will point out, oftentimes when we think about fairness, we think about group fairness. We think about, well, is it treating people from different countries of origin equally? Is it treating men and different equally, and so forth? What we care about here is the assignment between dockets. This result does not hold true if what we care about is fairness between different groups of people that are distinguished by their own characteristics as opposed to the assignment decision of which docket they are assigned to. I'm going to skip the proof sketch because I assume I don't have that much time left and skip ahead to the summary. We've looked at the three objectives that seem to be relevant in practice: delay, accuracy, and fairness. We've shown that the dedicated docket can Pareto improve the delay and accuracy, so it seems to have real operational benefits if properly implemented. But Attorney General Garland said that it would do so in a way that is prompt and fair, and we show that that cannot really occur, at least within the confines of our model. If it leads to any operational benefit, it must do so at the cost of violating fairness. Broadly speaking, and I'm going to use my last 20 seconds to express this sentiment, there are a lot of interesting scheduling policies that are being made in the asylum context, and there have been a lot of interesting changes to how asylum cases are being processed. Those have not really been analyzed by anybody who understands scheduling, anybody who understands queuing systems. So I think that what our work highlights, and I hope it's the first of many, is that in designing scheduling systems for this really important humanitarian societal system, there's a great importance for actual understanding of how scheduling policies affect queuing outcomes to actually be entered into the fray. And I'll stop right here. Thank you very much.
Thank you so much, Daniel. I think we have time for one question, a couple questions.
Hi, thank you for the talk, Daniel. I was wondering, is it the case that if you impose any kind of delay, finite delay, that you can't get fairness? So I would imagine if the delay time was the same for the two dockets, then maybe you wouldn't expect any difference. But is it important to have one unbounded time and one bounded to not get fairness between the two dockets?
No, I don't think so. So you could have both bounded, and effectively what would happen is if you have both bounded, then we haven't looked at it, but my very, very strong intuition would be if both are bounded, it's still the case that you can get an improvement, but that improvement must violate fairness. I don't think it should affect it in any other way. Brian?
Yeah, so part of my takeaway is that I had no idea how important kind of the interaction between basically the queuing sort of scheduling aspect and legal representation was in this domain. And I'm curious if your model has anything to say basically about capacity expansion in some sense, right? None of the numbers on these plots are very good in some sense, and where would we push things to improve the system?
Yeah, I think the problem is that if you look at what, for example, the immigration bill that was before Congress earlier this year, it aimed to increase the capacity of the court. And ex ante, as you think about the delay, that would lower the delay, and that is one of the objectives that we care about. But that has a really bad outcome if you don't also increase the capacity of lawyers. Now, it actually turns out that if you really increased the capacity of the court, then lawyers will only have cases for a week at a time, and suddenly they will be sort of underloaded, because even if they take on all the cases, each case, the service time gets reduced by a lot. But I think the quick answer to your question would be, if I like if I got to just invest into something, I would not invest it into capacity of the court. I would, based on what we've looked at, invest it in having more lawyers. So in the paper, you will find a similar plot to the one that I showed, but rather than moving this way, as you add more lawyer capacity, you can still move up. All the comparisons that we've looked at here are effectively comparisons that keep the resources in the system constant.
Thanks.
I think one last applause for our speaker. We're tight on time. Thank you.